Daniel Penny has been arraigned and released after having been officially charged with second-degree manslaughter for the death of Jordan Neely on the subway in New York. And even though Alvin Bragg, the Manhattan DA's office, and the Democrat media all want Penny convicted, Daniel is still entitled to the presumption of innocence, and he has several valid defenses under New York law. We'll review several of those today, but first, let's get some background on this story from NBC News in New York and dig into what happened in court, because he was arraigned, which means he appeared in front of the court, declared himself to be not guilty, and the judge set release conditions, including a $100,000 bond. Also ordered not to leave the state of New York, which is not anything unusual. This is Daniel Penny walking out of court, several officers to his side, and we have some details on this. 24-year-old Marine seen putting Jordan Neely, the deceased, in a chokehold on the F train in Manhattan, now being charged with second-degree manslaughter. And we're going to take a look at the statute as well as some statutory defenses. He was dressed in a gray suit, didn't enter a plea at his 15-minute hearing, so I correct that. He was released on a $100,000 bond in order to surrender any passports. He also must ask the court's permission if he wants to leave New York. Due back in court July 17th, said nothing to reporters, turned himself in, all done at the request of Alvin Bragg's office. Penny's attorneys previously released a statement, and the Neely family responded, and so I want to dig into some of that in a minute. But if you missed the video, it was released. It's been on the internet for some time. Not going to replay it here, but it is showing Mr. Neely here in a headlock, and Mr. Penny is putting him in a chokehold. And there are several people in the nearby vicinity who are also assisting. Not only did we have Mr. Penny, but we also had this bystander standing right there watching the whole incident, and even at one point helping by putting his hand on Mr. Neely's shoulder to keep him contained. We also had this other third individual holding both of his arms to keep him down and in control while Mr. Penny was holding him and restraining him. So several people were there, other people were filming, and it seemed as though the situation was under control. As we know, Mr. Neely passed away, and there were several things that happened shortly thereafter. Penny's defense lawyer released a statement, and Neely's family responded, which we will read here in a minute. But first, let me share with you some of the immediate reaction. AOC was very upset about this, as she usually is. She came out immediately and said, Jordan Neely was murdered! But because Jordan was houseless and crying for food in a time when the city is raising rents and stripping services to militarize itself, while many in power demonize the poor, the murderer gets protected with passive headlines and no charges. It's disgusting. Now, obviously, she posted this before he was charged, and he has been charged, because we know that Alvin Bragg's office bends to political power very easily. We know that they were not going to be prosecuting Donald Trump. Then Mark Pomerantz, former prosecutor on the Trump case, threw a hissy fit on 60 Minutes, and Alvin Bragg said, okay, I guess I'll do it. So when they were contemplating what to do about this case, people like AOC, people like Ritchie, Torres in Congress were screaming about this, thinking that this was a racist attack on a homeless person, and everything's getting militarized, and murderers are going free in their city, calling it disgusting. And she was upset about it, and so was Ritchie Torres over in Congress. Here's what he had to say.
Another troubling issue today. We're getting word about 13 people who've been arrested after protesters in New York City clashed with
insurrected
police,
the subway,
jumping onto subway tracks, this over the chokehold death of Jordan Neely. Police say that Neely, a homeless man who struggled with mental health, was threatening passengers when rider Daniel Penny put him in.
This is interference with democracy. This is a deliberate conspiracy to interfere with the peaceful transfer of location. And they're just getting away with it. Nothing is being done to round up these subway seditionists and put them in solitary confinement next to the J6ers, but there should be immediate action.
In a headlock that resulted in his death. Penny's lawyer says Daniel acted to protect himself until help arrived and didn't intend to harm him. Attorneys for Neely's family say there has to be a clear line of when lethal force can be used by anyone. What's your reaction to all of this, and what does it say about how people view the homeless and how New York City's handling it?
Well, Jordan Neely was not armed with any weapon. He did not attack any person. He did not manifest any physical threat.
We're going to come back to that because we have to ask ourselves about self-defense and the defense of others. What type of activity, what type of conduct can you engage in, you or me or Daniel Penny or anybody in a situation like this, to defend yourself or to defend others. We're going to look at the New York law.
And so there was no justification for choking.
Pay special
Jordan
attention
Neely
to that
for 15
word.
minutes and
Justification.
ultimately choking him to death.
It's a legal term of art.
Mr. Penny should be prosecuted for homicide in some form, whether it's murder or manslaughter. If the feeling of discomfort becomes grounds for killing the severely mentally ill, then we cease to be a civilized society. We cease to be governed by the rule of law. If you are struggling with severe mental illness, if you have no control over your mental faculties, if you have no ability to distinguish between right and wrong, you're a victim of your condition, and you should be treated with humanity and empathy.
Yeah.
So he obviously has been prosecuted, and you can see how outraged people are about it. We check in with Mayor Adams from New York to see what his reaction is.
So one of the reasons that this story is really hitting a nerve is because this man appeared to be having mental health issues. This is something that you've talked a lot about, but I want to read to you. This is a response from the comptroller, Brad Lander. He tweeted this: New York City is not Gotham. We must not become a city where mentally ill human can be choked to death by a vigilante without consequence. There's also this from Alexandria Ocasio-Cortez, the Democratic Congresswoman. She said, Jordan Neely was murdered. What is your response to what they're saying here?
Well, both the Congresswoman and the controller is a citywide leader. And I don't think that's very responsible at the time where we're still investigating the situation. Let's let the DA conduct his investigation with the law enforcement officials. To really interfere with that is not the right thing to do. And I'm going to be responsible and allow them to do their job and allow them to determine exactly what happened here.
Hey, I semi-reasonable answer here from the mayor. Meanwhile, AOC is screaming, murdered! He was murdered! Rah! Everywhere she goes, because that's basically her only one of two settings. Now, I want to share with you the comment, the statement that was released from the family, from the lawyer for Daniel Penny. And here, well, that's not it. What did I do with it? The statement they released. Daniel Penny's lawyers released the following statement by Stephen Reiser and Thomas Kniff, published May 5th, 2023. This came out before Daniel Penny had been charged. They write, the law firm of Reiser and Kniff represents Daniel Penny, a 24-year-old college student and Marine veteran. Young man, served the country. Earlier this week, Daniel Penny was involved in a tragic incident on the New York City subway, which ended in the death of Jordan Neely. And that statement is fine. Involved in an incident that was tragic, and it ended in the death of Neely. He was involved in an incident, but wasn't the cause of the death of Neely. We would first like to express on behalf of Daniel Penny our condolences to those close to Mr. Neely. Mr. Neely had a documented history of violent and erratic behavior, the apparent result of ongoing and untreated mental illness. When Mr. Neely began aggressively threatening Daniel Penny and the other passengers, Daniel, with the help of others, who we talked about, acted to protect themselves until help arrived. We were in fear and we were acting to protect ourselves, but they didn't say anything really about fear other than aggressive threatening. Now, here's where we get into a little bit of a concern. Daniel never intended to harm Mr. Neely and could not have foreseen his untimely death. So foreseeability is certainly an important issue in the law, but it's not exactly relevant here. It says Daniel never intended to harm Mr. Neely. This word is troubling because intent doesn't necessarily mean what we think it means when we read it as laymen. When we talk about murder and homicide, there are many different ways to disambiguate intention. You can wake up and go and intend to murder somebody that day. That's called premeditated murder. You can wake up, not intend to murder anybody, but walk in on something bad happening, and you have, in a heat of passion, an intent to murder, crimes of passion. A little bit different than premeditated. We have different situations where you can be acting recklessly and somebody can die, and you didn't intend for that person to die, but you did intend to do the thing that was reckless that led to the death of the person. And so if he never intended, okay, what different murder charge are we talking about? Because there's all different types of murderous intent. Premeditated, passionate intent. You've got reckless intent. Which kind? Could not have foreseen his untimely death leads me to believe he's talking about the recklessness. But it still doesn't disavow the intention to do the thing. which they're going to claim was reckless. In other words, he intended to do the chokehold, and they're going to say the chokehold was reckless regardless of his intent to kill him. Obviously, he didn't intend to kill him, but that's not the only way you get charged with manslaughter or murder. You can also be charged with other things when you've got different mental requisites and a different mental state. In this case, it could have been reckless. He could have just been intending to hold him there, but he did die. And so this sentence to me is reading almost as though he did commit the conduct, but didn't intend to cause the death. And so this last sentence is almost admitting to doing the thing that caused the death. He just couldn't have foreseen it. So he's almost challenging the reckless element. Let's come back to this. They say for too long, those with mental illness have been treated with indifference. We hope that out of this awful tragedy will come a new commitment by our elected officials to address the mental health crisis on our streets and subways. So this is taking it out of Penny's responsibility, blaming the government. And so now we have to ask ourselves if there were any admissions in this statement. Neely's family certainly thinks that there are. They write this: for immediate release, Neely's family responds to Daniel Penny's admission of guilt. They got their own lawyers, and they said Daniel Penny's press release is not an apology nor an expression of regret. It's character assassination and a clear example of why he believed he was entitled to take Jordan's life. That's what they said by calling him mental health and untreated, and he was violent and erratic. They're assassinating his character. This is why you don't say anything. In short, his actions on the train and now his words show why he needs to be in prison. They say Daniel's press release is an attack, a clear example of why he believed he was entitled to take Jordan's life. In the first paragraph, he talks about how good he is, and in the next paragraph, he talks about how bad Jordan was, in an effort to convince us that Jordan's life was worthless. The truth is, he knew nothing about Jordan's history when he intentionally wrapped his arms around Jordan's neck and squeezed and kept squeezing. In the last paragraph, Penny suggests that the general public has shown indifference to people like Jordan, but that term is more appropriately used to describe himself. It's clear he is the one who acted with indifference, both at the time he killed Jordan and now in his first public message. He never attempted to help him at all. I don't think that's true. I saw video after the fact where they were moving him into a recovery position. After you're blacked out or choked out, you're not supposed to lay on your back in case you start vomiting or you start swallowing your own spit or your tongue or you can't breathe. So you want to roll somebody over to their side so that they've got a clear airway. In short, and we saw him do that. In short, his actions on the train and now his words show why he needs to be in prison, says Dante Mills and Lennon Edwards, two lawyers. So they just are latching on to everything that this team has given them. They say, Mayor Adams, please give us a call. The family wants you to know that Jordan matters. You seem to think others are more important than him. You cannot assist someone with a chokehold. Hashtag homelessness, hashtag mental health, from these two lawyers out of New York, published on May 8th, 2023. So we see how this is going. Obviously, they're going to want to get a big settlement, big verdict out of the Penny family or out of the Penny funds, which are being raised. But we have to ask ourselves, what defenses does Daniel Penny ultimately have? Let's take a look at some of the law as it exists in New York. First thing we need to start with is going to be ruling about the cause of death. And the story tells us that it was ruled a homicide, but every time we see these things, we're always very hesitant and skeptical to take them at face value, just simply due to the fact that evidence changes very regularly. And we remember watching the George Floyd video and presuming that we knew what the cause of death was there, thinking that it was asphyxiation from the knee on the neck. But it turns out that wasn't true. The heart gave out in George Floyd's body, as the medical examiner for the government testified, very likely as a result of arterial sclerosis and hypertension. His arteries were clogged shut, and he was also had fentanyl in his blood and methamphetamines in his system. And he had just gotten done wrestling with the police for several minutes as they were trying to subdue him and get him in the back of the car. So it all was cumulative. It all added up. And we learned that at trial, but everybody had already seen the video and already come to their conclusion, the evidence be damned. So here we can do the same thing. We can take a look at the chokehold and ask ourselves if that was the actual cause of death, and it could have been contributory, or it could have not. It could have just been his heart gave out, and we don't learn that until they get a full autopsy completed, which to my knowledge has not been done yet, as this is a recent case. The death of the man who was captured on video being placed in a stranglehold has been ruled a homicide, which just means another person caused the death of another person. What did they write the cause of death for? Identified was determined to be compression of the neck or a chokehold. And this is the immediate report, right? But it's all over the media. And I want to see the full documents that we got to see when we covered Chauvin. Let's see if there's any more detail here or if that's it. This is a solemn and serious matter. We will review the medical examiner's report, access all video, and interview as many people as possible. 30 years ago, I fought this case. He was 30 years old. NYPD said Neely was unresponsive and was brought to a hospital where he was pronounced dead. He was homeless at the time of his death, and we hope the family is okay. New York law, section 125.15, which is manslaughter in the second degree, tells us very simply, a person is guilty of manslaughter in the second degree when one thing happens that applies to this case. He recklessly causes the death of another person. And this is the mental state. This is why in the letter, when Penny's lawyer says he didn't intend to cause the death, doesn't matter if he intended to or not. If you act recklessly and do the activity, do the thing that the government says is reckless, and you cause the death of another person, that's it. So we're not arguing intent now, we're arguing recklessness in many ways. The other way you can get it is if you help another person commit suicide. That's not obviously applicable in this case. So that's the law. That's all we get. Not a lot there, but we can unpack it a little bit further by taking a look at the jury instructions. And so this is what would go to the jurors if they were deliberating on this particular count. They say, ladies and gentlemen of the jury, here's the deal. Under our law, a person is guilty of manslaughter if that person acts recklessly with respect to a death, when that person engages in conduct which creates or contributes to a substantial or unjustifiable risk that another person's death will occur. Now, we've got some meat to unpack on that one. Does a chokehold contribute in a substantial way and create an unjustifiable risk of death? I'm not so sure about that. That's why I'm not ready to cede this causation issue. I've been put in many chokeholds, and I've given many chokeholds, and I've never killed anybody or been killed. In fact, I think it's probably the safest way to dismantle somebody who is in a very disturbed state. I don't know if there's any other way to do it. You can crack somebody in the head and knock them unconscious. You can put them in an arm bar or some other type of joint lock, but oftentimes they still have a leg or a hand free and they're still conscious. So a chokehold is a very nice way, in fact, often regularly taught way in police agencies and police academies all over the place on how to specifically calm somebody down and take them down without injuring them. So was the chokehold reckless? There's going to be a lot of argument that it is not, that there are 12-year-old girls doing chokeholds in gis, in mats all across America regularly, and nobody's dropping dead. And when she is aware of, or he, in this case, Penny, and consciously disregards that risk, Was anybody telling him he was dead? Was anybody screaming at him, get off him? He's dying. Leave him alone. No, they were all helping him. There were two people standing right there. He wasn't consciously disregarding anything. In fact, there were people assisting him. This guy was holding his other hands, and this guy was standing right by and putting his hand on his shoulder. So there were multiple people who were involved in this, all supporting him. So I don't know what a conscious disregard looks like, but I don't think that was it. And when that risk is of such a nature and degree that it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. And all of these things have to be true. A person acts recklessly. This is the standard that they've got to meet. Did Daniel Penny engage in conduct that creates an unjustifiable and substantial risk of another person's death occurring just from a chokehold? I don't think so. Was he aware of that this person was dying or going to be dying and consciously disregarded it or put on the chokehold knowing that it was going to cause a death? Was that in his mind somewhere? And did it look like that? And when that risk is of such a nature and degree that it would be a gross deviations from another conduct. So if somebody else was there, would they do something completely different other than nothing, right? Other than just stand there and maybe get attacked, maybe get injured, maybe get stabbed or killed or spit upon or assaulted in some way. And you don't have to sit there and be assaulted. Would another person do something similar? I think so, because there were two other people who were also helping and somebody was filming it. So this standard, I think, is going to be a little bit harder to prove than maybe they think. Okay, it's not just that he caused the death of somebody. it's not just the chokehold. It's a recklessness about the chokehold. And when we add in some additional context to this, and if Neely was being violent and threatening and throwing things, causing criminality to be imposed upon somebody else's person, we're going to talk about justification in the defense of yourself or the defense of others. They say a person also acts recklessly when he or she creates such a risk, but is unaware of that risk solely by reason of her intoxication. No evidence that this guy was drunk or under the influence at all. So those are the elements. And it's a little bit trickier of a standard because of that recklessness. And is a chokehold reckless when somebody is attacking you? Should he have just shot him or stabbed him or hit him in the head with something hard and knocked him unconscious? Would those have been more reasonable things to do? Or was this actually kind of in alignment with the standard of conduct that would be appropriate? Was this not a deviation really at all? Would most people kind of do something like this if they were under attack? In fact, is this one of the most reasonable things to do? So it's not reckless at all. Yes, it caused the death of somebody else, but we know that not every time somebody causes the death of somebody else, they have to be charged. There is something called prosecutorial discretion in this country. And sometimes prosecutors decide it's not appropriate to charge somebody. Take a trip over to New Mexico and ask the prosecutors who have decided not to charge Alec Baldwin, who shot and killed a woman. Accidents happen. The world is a bumpy place, and not everything is criminality. Not everything has to be prosecuted, unless you're getting screamed at by people like AOC. So that's what the jury would take a look at, and we would ask ourselves how they would interpret that. But we also have to take a look at this other section. There is a provision of New York law called 35.15, which is the Justification Provision. Justification is a concept that says you're allowed to do some things if certain things apply. Here's what it tells us. You can use physical force in defense of a person when the following things happen. And this comes from New York law, Article 35, the defense of justification, section 35.10. A person may, they say, subject to the provisions of subdivision 2, use physical force upon another person when and to the extent he or she reasonably believes such to be necessary to defend himself or a third person from what he or she reasonably believes to be the use or imminent use of unlawful physical force by another person. That's it. Unlawful physical force. Throwing garbage at somebody, spitting at somebody, smacking somebody, being assaulted by somebody is unlawful physical force. You're not allowed to assault somebody on the subway. If you're mentally disturbed or not, you're not allowed to do it. And you don't have to sit there as a citizen in New York. Maybe you do now. I'm not sure what the law, how it's going to be implied now. But in a prior era in America, you didn't have to just sit there and be abused by people. If somebody is assaulting you or causing you to be in reasonable belief that it's necessary to defend yourself, and other people in that same position, if they just swapped you out and put somebody else in and swap that person out and put somebody else in, would everybody think that it was pretty reasonable to do the thing? If so, then you're justified to do that. Now, you can't, they say there are some limitations to this. If you're provoking it, if Daniel Penny is provoking, and calling him names, and then he comes and attacks him, and then he uses it, you're not justified there. You caused it. If you're the initial aggressor, you can't do it. If the physical force is the product of a combat agreement, not specifically authorized by law, you can't engage in non-sanctioned UFC fights. Now, you can't use deadly force. This is a little bit different, and I wouldn't call a chokehold deadly force. Deadly force upon another person unless that person reasonably believes the other person is using or about to use deadly physical force. So in New York, you can only use deadly physical force when somebody else is using deadly physical force. And what people like Ritchie Torres were saying is that Neely was not using deadly physical force, and therefore Penny shouldn't be using deadly physical force. But he wasn't. He was using a chokehold. The actor may not use deadly force if they know that they can retreat with safety to do it. But again, Penny didn't pull out a gun or a knife or use any weapons. It was a chokehold. Now, they may be trying to say that a chokehold is deadly force and that invalidates the justification provision. But Penny's still got these defenses are coming at this in two different ways. The first defense we talked about was challenging the recklessness of the conduct, saying that it was not reckless conduct and therefore he is not prosecuted prosecutable because the elements of the mens rea, which is the mental state, have not been satisfied under the statute. A very similar defense is justification, laying it on top of that original defense. It's saying, yeah, look, this thing happened. There was an intent to put the chokehold on. I did intend to do that, and it did lead to the death, but I was justified to do it. I am allowed to do it because I was reasonable in my belief that the use of physical force was necessary in this particular situation. So the government will try to beat that justification defense by saying chokehold was physical force. It was deadly physical force, and therefore it falls into this category, subsection 2. And because it falls into this category, we can look back and also look and see that Neely didn't have any physical weapons, or he wasn't using deadly physical force, and therefore Penny shouldn't have been able to use it either. And so they'll try to pull him out of that subsection, which would eliminate that defense for him. So that, I think, argument is going to hinge on whether chokehold is deemed to be deadly force. But again, I don't see anything here that would remove justification as a defense for Daniel Penny. He didn't provoke the conduct, and he wasn't, from what we know, the initial aggressor. And so as long as it appears to be that it was reasonably necessary to defend himself or a third person, anybody else in that area, using what they reasonably believed was physical force to prevent the imminent use of the attack, they're allowed to do that. And if you swapped out Daniel Penny for me or for you or for anybody else, and it seems reasonable in the same environment, we're going to say that justification defense comes up like a force field and immunizes Daniel Penny from the conduct. He was allowed to do the thing because it was reasonable for him to be in defense. So we've got two interesting defenses there that I think are going to be a little bit more complicated for Alvin Bragg than he lets on. A lot of people in the media just say, well, he choked somebody out, so therefore he's dead. Well, it's kind of the same situation. You can analogize that to Alec Baldwin. Say, well, he pulled the trigger and somebody's dead, and he didn't get charged. Why is that? Is it because he's part of a favored defendant class in America? Prosecutors hold him to a different standard than they would a 24-year-old Marine? I don't know. But in New York, it seems like they have a vendetta. Alvin Bragg and Letitia James have both been elected to prosecute their political opponents, starting with Trump, and they're not ending there. But Daniel Penny has been absolutely in need of support, and he has been getting it in good numbers. And this is great news. If you want to donate, and I would encourage you to donate to Daniel Penny's Legal Defense Fund, because he's going to need a bunch of defense here. He's going to need people to explore all of those different angles and probably get his own expert witnesses to review all of the materials, all the autopsy reports, the medical examiner's reports. He's going to have to do his own investigation into Jordan Neely and his background and see what they can create and uncover to show that this was not a reckless manslaughter. This was a situation where Daniel Penny was justified in his defense, and a bad thing happened, unfortunately, but he doesn't need to be prosecuted. So he's going to need a whole team of people to do that. They've got their legal team already working hard, Reiser and Kenneth, and they've raised $1.27 million already. So I would very much encourage you, if you can, to go make a dono over here. We'll put the link in the description. It's Give, Send, Go. Daniel_Penny is the address. It looks just like this. They raised $1.2 million. And so that's going to go a long way. This is a Give, Send, Go. Yes. Give, Send, Go will receive the money. And there was some concern earlier in the day that that this page was down. Apparently the volume, the traffic to this page has been so high that it actually overwhelmed their servers. And so thank you to everybody who's given for this. Keep on giving if you're out there, and we will do the same. But of course, we'll continue to follow this case. Thank you for joining us as we do. Thank you for spreading the word, sharing this link with your friends and family, and letting them know that there's a lot of people out here who will stand behind people who will still do the right thing in this country, people who will see something bad going on and they'll step up to make sure other people aren't being attacked and abused and being threatened and assaulted, and then they get prosecuted and made to be the scapegoat in this new era in New York, and hopefully not happening elsewhere around America. So go here and donate, and we'll look forward to seeing you on the next one.